Thank you. Good morning. Keith Moscowitz, as most of you know, I'm one of the attorneys in the group. And I emphasize estate planning, probate, and bankruptcy, which means I'm the person that has to talk to you about things that you don't want to talk about. And this is one of them. Today we're going to be talking about just an overview of estate planning, guardianship, and probate. So what is personal and estate planning? Well, let's say a number of things. It's a durable power of attorney for financial matters, a power of attorney for healthcare and medical decisions, healthcare directive, which is also called a living will, organ and donation and burial instructions, your last will and testament, and trust. What a durable power of attorney is, it becomes active when you can't make decisions for yourself. It can be a temporary basis if you're in an accident or you're sick and you can't make decisions for a short time, or if you get to a point where you can no longer make decisions for yourself for whatever reason. A family member, it could be an agent or another agent appointed, can make those decisions for you. A healthcare directive. This is something that people often overlook, but the last thing that you want to do is have your kids go, what would mom and dad want me to do? This is a roadmap for them. This is telling them what you expect and what you want them to do. It takes the burden off of them. Organ and donation and burial instructions. What do you want done? You know, again, if you're close to passing away and all of a sudden, you know, the hospital is coming to you, will you donate organs? Don't have your children make that decision, or your friends or family. Make it in advance. You know, what are your last wishes, you know, for burial, cremation? Again, it's making sure that your wishes are known. You know, why do you need a will? You know, I say that every morning, and I think, how many people have a will right now? Less than a third. If you don't,
terrible.
I'll just say, my brother died a year ago. I just settled his estate. It took a year to get a will.
if you don't have a will, if this is Colorado, the state of Colorado statutes are going to decide who gets your property. It may go to somebody that you don't particularly like or don't think it's proper, or if it's a child. You know, the last thing you want to do is give a 21-year-old, as Dan can probably say, a couple $100,000. You know, in 3 Corvettes, it's gone.
Probably have to go to a lawsuit.
Some of the factors that you need to consider: your family. You know, do you want to take care of your spouse? Who do you want to take care of for your children if you have young children? Yeah, and as anybody knows, Janet and I, if you've met us, what's going to happen to our cats is more than important. It's something that's very important to me, obviously. Okay? You need to look at your current and future health. You know, if you are, God forbid, having a health issue that could be very serious, it's a good time to look at your will and make sure that it's up to date. And what are the goals for your family? That's something you need to consider. You know, what type of assets do you have? You know, real estate, you know, retirement, pension, insurance, or other investments. Other estate planning documents is a revocable living trust, a testamentary trust for children or spouse, a special needs trust. And one of the real reasons people ask me, well, I want a trust. Well, you don't really need a trust except in certain cases. If you have a will, it gets lodged with the court. It can be read, it's not private. So, you know, a trust will provide privacy. If you own real property in multiple states, it's much easier to transfer the titles to the next generation or whoever you want to go to it through a trust than through the probate process. So when do you review your will? You know, if you're 35 and have a will, is it the same will that you should have when you're 50? Probably not. You know, some circumstances you have to look at is marriage or divorce. If you have a new child, once your kids become emancipated and they're out of the house, your will no longer needs to provide for guardians. If there's special needs, financial circumstances, we also have to look at the tax ramifications. Those are reasons to review your wills. You know, a guardianship, it can be used for the very young or the very old. It can be used when, and it's a court proceeding, where a guardian is appointed to look after a person's assets, make financial conditions, and medical. So if a durable power of attorney is contested, or if the person appointed as the agent won't do that, that's particularly very important to me because that's my mom right before she passed away. We did have to have a guardianship. And maybe you know that's my daughter. There are certain times when we have to, go to the court and ask for a vulnerable adult protection action. If an elderly person or a young person, if an elderly person is being abused, if it's neglect, whether by a caregiver or the person herself or himself, or if there's financial exploitation, which we see much too often. So, what is probate? It's a court process to marshal the assets. That means to gather all of the assets in one place. It's to pay any taxes. It's to determine what valid debts the person has and to pay creditors. And then to distribute the estate for the terms of a will, or if there's no will, pursuant to statute. So there are essentially two types of probate. One you want to avoid at all costs, and that's intestate. It's very expensive, it can require a bond, it's court supervised and appointed. It can be avoided by coming to see me. Let's get your will done, or if appropriate, a trust. If you have a will, it's a testate, you can choose who your personal representative is going to be. There's no bond required, and although it's lodged with the court, generally it's done without court supervision. Thank you. Any questions?
Keith, I've got a client that asked me a question the other day, and I wasn't sure how to answer it. She said that she handwritten her will, years ago, and she can't really read what she wrote now, but she said that somebody advised her a long time ago that handwritten wills are actually better, that people will not contest
Absolutely
it.
not.
So I didn't think so,
Absolutely.
but I told her to consult
Absolutely
with a lawyer.
not. What you really want to do is do a formal will.
Yeah.
You know, it is signed in front of two witnesses, so if there's any kind of will contest, we can find the witnesses. So it makes much more sense to have a formal written will.
Okay.
Any other questions?
Yeah, how much are you charging for your will packages?
You know, it's depending on what we need to do, anywhere between $400 to $600. You know, for a basic will package, and that includes a durable power of attorney and medical power of attorney. It depends what we need to do. If there are spillover trusts, we may adjust it. And if we do a formal trust, then, it's on an hourly basis. Okay.
What can you put in place to ensure that your will is actually executed? I mean, so that you don't, where do you establish it so that it actually gets read and followed through by?
Okay, couple things. Number one, never, ever put a will in a safe deposit box. Because the safe deposit box gets sealed and it becomes a real problem. So you want to have the original, have the person who's going to be your executor know where you're keeping it. I'd also recommend giving the executor a copy, usually in a sealed envelope. And so that's the best way to do it.
We also keep a copy of all of our financial plan clients' estate documents. So we tell them, the executor, beneficiary should always have our card to call us. Really concerned for us as well.
You had a thing up there that was for elderly people that are abused. I have a dad that I don't think is competent to take care of himself anymore, but he thinks he is.
And then you can,
In the state of Arkansas, that's no different.
well, what you can move is for a guardianship.
Then do I have to be in that state? Or you appoint a separate one?
Yes.
Different?
If you're not there and you don't want to do it, you can have an attorney appointed. Occasionally I've seen a social worker, appointed. So that's something you can definitely work around.
Are there different rules to building trusts in different states?
Yes.
Okay. And so sometimes it's more advantageous to have it drawn up in a different state?
Potentially, yes.
That's a good point too, though. If you move, all of state law is state specific. So if you move from one state to another, that is a very good time that you should have all of your state documents reviewed, because what one state does, particularly when you're dealing with community property versus non, will be very different from what another state does.
And God forbid you're from Louisiana.
That's
It
not where
follows
you are.
Napoleonic law.
It's another reason not to leave.
Really good food though. It's tough. Crappy weather.
Okay. Thank you very much. If you have any other questions, just let me know.
Thanks, Keith.
Okay. Thank you.